Hi, everyone. Welcome. We're excited today to offer our sixth webinar addressing the legal impacts of coronavirus on K-12 schools. My name is Jackie Gharapour Wernz, and I'd like to reintroduce our regular panel. We have Shelli Anderson,
Hi, everyone.
Nicki Bazer,
Hi, everyone.
Fattore Crumley,
Good afternoon, everybody.
and Jennifer Smith.
Hello.
And for those of you who follow us on Twitter, you know that we were planning to have a special guest, and I gave some hints that it was going to be someone with particular insight on special education issues. So we're excited to welcome Franczek partner Kendra Yoch to join us today. Welcome, Kendra.
Thank you. Hello, everybody.
Now, before we jump into our questions, let me provide my general housekeeping notices. If you would like to ask questions, please use the Q&A function on Zoom to do so. You guys know the drill by now. During the first half of the webinar, we're going to be addressing questions we received either during the registration process, for the webinar, during the last webinar, or from clients and friends. The second half of the program, we're going to address questions we receive from the Q&A function on Zoom during the webinar. So I highly encourage you to click on the Q&A box and submit your questions. As always, if you find yourself looking for more information or if we weren't able to answer your question today, please reach out to one of us for more information. And please also check out our website at franczek.com, where you can find our COVID-19 Resource Center full of webinars, alerts, blogs, and podcasts. Make sure to subscribe to our alerts because we are regularly adding more material. All right, with that, let's jump in with our first question. And we always like to put our guests on the hot seat. So Kendra, our first question's for you. We know ISB released new special education guidance on Monday in the form of an updated frequently asked questions document. Can you give us a summary of that guidance? And then I'd love some general thoughts from the group as well on what it all means.
Sure. So I guess, first of all, it was released on Monday, which is a welcome change from the usual Friday release of these guidance documents. Beyond that, I have to say, we've heard and we felt a lot of frustration. To ISB's, in their defense, they don't have any authority to change IDEA. It's a federal statute. They can't grant waivers. They can't grant flexibility. I think some of the prior guidance that ISB has given on other topics has included a little bit more of a roadmap. How should districts adapt in these unique situations? What are the legal requirements? What can we do? And how should we think about it? And this didn't really have a lot of that. It was mostly repeating that there's no flexibility in the law. We need to follow IDEA. All of those requirements remain in place. And to the extent that you're trying to figure out these more nuanced and complicated questions, you should be consulting with your board attorney, with your administrators. So there's not a lot of new information. And I think it does, while sometimes having a little bit more of that roadmap is helpful, it leaves districts a lot of flexibility to figure out those things in a way that's going to work for their school community and work with their legal counsel to be a little bit more creative. I will point out one thing that was a clarification that might be helpful. When we're thinking about the question, is a school day when we're counting timelines, and that particularly applies when we're doing evaluations. They've previously said that the active God days are not school days. Remote learning days are school days, but remote learning planning days are not school days because those are not student attendance days. So that does give districts, a couple extra days there that would not count toward that 60-day timeline, which is helpful. Dana, Jennifer, did you have other thoughts when you were reviewing it?
Under the sort of category of every little bit helps, that would be the Jeopardy category. I think the other sort of way to look at this that we had talked about is, this guidance comes sort of after the start of this. So that means that I think the silver lining here is if they had given more directives and districts were doing something that was contrary to those directives, we would have to really, change gears midstream, and that might be difficult. So there is, while they don't give flexibility, I think there is room for districts to be creative to, to work, since ISBE's not giving us the framework, to work with your neighbors and your peers in the field and try to brainstorm and be creative and find ways to deliver this instruction to this population of students. Jennifer, what do you think?
Yeah, no, I definitely think we've been talking about whether we should be asking ISBE for follow-up guidance or not, and the pros and cons of that. And I mean, where I come down on that is you're better off. I mean, you are midstream. You've chosen your horse, at least for the rest of this school year. Don't ask a question that you're going to get a bad answer to and that your parent community is going to see. Let's just ride this out a little bit. You know, I'm getting questioned about, is this way? Is it okay to do only recorded videos? Do we have to do live calls? Do we have to do instruction this way? Right now, that is all that flexibility is yours. You are not, all you're told is you have to provide figure it out. While frustrating, it's also liberating in that there are no wrong answers yet on what that looks like. So, you know, I think that is consistent with what Dana and Kendra are saying. We're left to figure it out, but on the good side, we're left to figure it out. So.
Now, what about pending special education evaluations? Has there been any additional guidance on means and timelines now that we know for sure that face-to-face school will not occur for the remainder of the school year?
So that really hasn't changed from before because we don't have any changes to the law or particular flexibility. The timelines are still in place, and teams should be looking on an individual basis at what does an evaluation entail. Can you do some of these assessments remotely as far as interviews, rating scales, and then collaborating with parents to figure out, you know, do we need to amend the domain form? How are we going to get this done? Can we get an agreement to finish it after school resumes in person? And each case is going to look a little bit different, whether or not you can look at data you already have and collect new information to answer the questions about eligibility, or whether you're really going to need additional information once we get back face to face.
Now, Jen, we've heard whispers that there may be some federal funding that's been proposed to support special education. What do we know about those proposals?
Yes, so we have seen proposals that there's an extra 10 billion. Senators Murphy and Cassidy are pushing for, and the groups that I'm involved in, the attorney groups, there's been a discussion and a lot of thoughtful. I want to give credit out. There's a counsel, Gerald Zellin, and he really did analysis of, okay, 10 billion sounds like a lot, but when you think of the number of special education students across the country and the average cost of special education, it's a mere drop in the bucket. I mean, it would be only slightly more than $1,000 per IEP student, which when you're thinking about the average cost of special education, you know, the average cost for a gen ed student might be $12,000. We know special education is maybe even double. To only put another $1,000 from federal sources because of the pandemic, that is not going to go very far when we're hearing about major comp ed requirements being discussed. You know, people should not get too, you know, it's nice to hear big numbers, but that on a student basis is not that big.
Dana, I know ESY is on everyone's minds right now, it seems. Since the governor said he's not making a decision for summer programming at this time, I know schools are struggling with the decision about whether to hold remote ESY or to plan to hold it in person, since it will directly impact things like the hiring process. And also, we know many parents are struggling to help students with disabilities with remote learning at home. So the question we received is, do districts have the ability to decide now to hold ESY remotely instead of in person?
You know, that's a really good question. I think that, again, the lack of, you know, definite guidance in this area gives districts the ability to do a lot of things. And I think probably the most prudent thing to do at this point is to have a plan A and a plan B. We don't know what it's going to be like in the summer. We don't know if maybe there's going to be some easing of the restrictions, especially as we move closer to the start of the school year. So I know that most of the districts I work with have sort of a system for ESY, and it's either, Monday through Thursday, or it's, a shorter amount of time for a longer period during the day, or it goes longer into the summer for a shorter period of the day. I think we're probably going to have to leave that sort of established routine behind and really look at different options, and maybe have two options ready to go. One remote learning option and one option that's more face-to-face. And then just, within that, providing for social distancing guidelines, if those are going to be an impact, and just, being creative. This is, for better or for worse, this is our time to really think outside of the box and work together on these issues. Jen, Kendra, do you guys have any other thoughts?
Yeah, I tried to get a pulse of across the country who's planning remote ESY and who thinks that there is an in-person option. Most council are seeing their clients move to a reality that probably it's going to be remote. It would be great if that is not the case and something happens, but as it inches closer, it seems like you're going to need to plan for a remote option for ESY. We know the requirement of providing ESY is not waived. So you are going to have to offer something, and knowing that with social distancing requirements, likely that's going to come in the form of remote. There's even discussion, we'll talk about this more. So even in fall, we don't know what fall is necessarily, what's going to change about fall to allow us to open up a 400 person to 4,000 person building. That's very complicated.
Yeah, and I just saw a couple questions over in the question box. And Jennifer, you just touched on one, is that ESY is still required. There's no change in that. When we're thinking about minutes, if we are able to return to in-person instruction, your minutes might stay the same as what's already on a student's IEP. To the extent that ESY is going to be remote, we're going to be thinking about doing remote learning plans the same way we have during the regular school year, to the extent that that changes or modifies the services the student would be receiving.
So for another ESY question, is it just assumed if the IEP team has agreed on ESY services that if things drastically improve, the student will receive minutes on campus, or if things stay the same, that they will receive them remotely? Kendra, any insights on that question?
Yeah, I think that's a similar idea to what we were just saying, is that, if you're in person and you can hold ESY as scheduled, then, we would provide those minutes as they're stated on the IEP. To the extent that that's not possible, and we're going to be looking at alternative programming that's in order to do social distancing or entirely remote, then it may require amendments the same way we've looked at during the school year.
Yeah, for those annual reviews that you're still holding now remotely, the meetings I've participated in, it's a discussion that teams are starting to have just as part of the process. So what does remote learning look like? Which goals are being worked on? You're getting feedback from the parent on what's working and what's not working. It hasn't formalized itself into a section on the IEP, but I think teams are starting to get experience. That's what parents want to talk about when you do those annual reviews, is tell you what's going on in their home and what support is and isn't working. So to just do it in a vacuum as if this isn't happening and like everything's going back feels less and less realistic, when it now feels this is not just a blip, this is something that we're going to be living with one way or another, and that needs to be reflected in the IEP discussion.
Okay, switching gears to think about employment for a minute, and then we'll bounce around kind of like we usually do, taking questions from all over. So we've talked before about teachers whose evaluations they can't be completed remotely, and so they're going to be receiving a default proficient rating. Has there been any more talk, Shelli, from the state joint committee regarding defaulting to excellent in some cases, or any other updates on teacher evaluations?
Right now we have not heard anything new from the joint statement coming out or from ISB related to this. I think if we all remember that the joint statement indicated that the unions in particular were going to be pushing for some legislative change related to this. I think the further we get on in the school year, the less likely we are to see that happen. I do think that most districts, though, who wanted to address this issue differently than perhaps defaulting to a proficient are finding creative ways to do that for their teachers. So right now, there's nothing new from the state, but I do think there's lots of creative ways that we've discussed, in prior webinars, and we've individually talked to our school district clients about how to handle that if that's something that the administrator wanted to do. But nothing new yet.
Okay, and then we know a lot of questions have come about practical realities of restarting school, and Jennifer alluded to this earlier. So let's kind of move into talking about that. So schools are facing issues like when buildings might be 2/3 empty when kids are coming back because of parental fear. How are we practically going to get things off the ground again? Dana, can you give us some thoughts on that issue?
So yeah, it's also hard to predict, but I think we have to start planning and being creative and thinking of the possible scenarios. So I think, one of the scenarios that we've heard, and one of the things that's been tried in other countries where they're opening up again, is sort of an alternate day schedule. And that, I think, has implications for families because, as kids go back to work, or as kids go back to school, parents will be going back to work. It also has labor implications, which I'll let Shelli touch on, because who knows how that's going to change existing schedules. I'd love to hear what Jen thinks about the school avoidant kids. I don't know if this is going to, if the impact of this is going to make them all want to come out and come back to school, or if we're going to see just a huge influx of people who decide, I'm not one of them, I would like to get out of this room at some point, but of people who decide that they're okay with just learning remotely because this really works for me and I don't want to see everybody in my class. And so Jen, what do you think?
I think it's absolutely going to be a huge problem. Both we saw school avoidant kids. We know when you're out a certain period of time. So we have experience. I've had students who have major medical issues, like maybe they deal with cancer or something where they're out a long period of time. That can lead to some school avoidance, and it always kind of weaves in and out of issues that are legitimate and issues where it feels like school avoidance, and it's very difficult. So when the student says, what if they say, the parent says, well, they have an underlying condition, and so they have anxiety about coming back to school. We want you to continue remote learning. They have diabetes, or they have something that puts them at risk. So that's going to be scary. Or the kid's just anxious. I think we're going to see that skyrocketed and need to have a plan. The savvy parents will get homebound certification. And I know that we'll get doctors that will hand those off. You'll see the same form a million times. So what are we going to do? There has not been any easing yet of that law that requires homebound. I have been advising that when parents, I've had parents seek it now because they really don't like the remote learning. So they've asked for their own homebound teacher with a homebound certification. And so far, since we're fully remote, I've said, no, remote learning, you don't get your own teacher. The need has been met through remote learning. But if we have all the teachers return, Shelli, who's going to be doing all this homebound that I expect we're going to see people demanding?
I think that's one issue that's going to come up in terms of a staffing, but I think you're entirely right, because as we were talking about before, when we were getting ready for today, it's not just the kids that may have an issue with coming back and your children who are already school avoidant or have an underlying issue, but let's talk about the parents who might not feel totally safe of having their kid go back to school or whatever the transition plan is. And then how do we handle that? Because if it's the parent, you're right, any creative parent can find a way for it to appear such that it's school avoidance and they have to provide homebound. So I think that we're going to be really faced with both the student perspective as well as a parent perspective about being concerned about having their kids come back and how we're going to staff all these different issues.
Yeah, we had a question come in, Shelli, and I'd love to get your thoughts on this too, on whether we would need, if districts end up doing what Dana is suggesting and having staggered schedules, would we need MOUs with the labor unions? to set this up. And I think absolutely we're going to have to negotiate changes with our teachers, with our support staff, if next year looks very different from a schedule perspective. I know that these questions are also being discussed at the highest levels of the state. So we might indeed even see, guidance or legislation or what have you, but at the very minimum, we're going to need to be in communication with our labor unions with whatever sort of schedule or idea we set forth for next year.
Absolutely, because I think most of the compensation, the benefits pieces are all predicated on what everyone's comfortable with the schedule looking like, with some broad parameters to it. And if we're really significantly changing that in any way, there is going to have to be much discussion and bargaining with all the applicable unions.
So jumping in, another legal issue that we can anticipate with a return to school is the return of truancy requirements. Right now, I'm getting a lot of feedback that there's a significant chunk of students and parents that are completely missing in action. The students not turning in any work, the parents completely non-responsive to emails, and we're advising through that. If the truancy law is returned, but we're still in some sort of remote or modified situation, what are we doing to track people down remotely? How are we enforcing truancy laws that you have to log in or you have to turn in an assignment? That is, what does attendance mean going forward? If your parent fills in yes, they attended, but we're getting no work at all, are we going to reinstate grading requirements and credit expectations? There's a lot that needs to be thought through from that perspective as well.
Absolutely. That's like almost a whole new area of opportunity for some, web-based companies to come into play to sort of keep track of where everyone is. And that's been a real problem in some districts. And it's like you almost want to have a carrot and a stick approach, because if we do too much of the stick, we're just going to lose people even more.
Now, also in the same realm of what's going to happen in the future, the crystal ball, there's been so much heartbreak among students and parents, staff, administration about students missing out on really important activities. Shout out to my nephew, who is a senior this year and is looking at missing his graduation and his end of year band concert. What are the legal concerns that schools should consider when planning around, are we going to have these activities, or what are we going to do with these expectations?
Sure. So first, this is heartbreaking, and we know that these rites of passages are so crucial for our students, particularly our seniors. But I'm now going to give you the total lawyer answer. So a couple considerations. First, try not to overpromise what you're going to provide to your students and parents at this point. Even if we have a lifting of the shelter in place, we are likely to see that it is gradual. So that you'll have gatherings of 50 people, maybe 100 people. We don't know for sure what the governor will do, but that is definitely within the realm of possibility. And so we want to be careful about promising, say, a graduation ceremony in July or August, and with no understanding at this point of what that shelter in place is going to look like. The second thing is if you're going to go ahead, though, and just plan something for that time period with the hope and expectation that it might happen, please make sure that you're looking at the contracts that you're signing with any venues, with any service providers, and make sure that you have a good, solid out from any contracts. Talk with your attorneys, review them, because obviously you don't want to be on the hook for a large event and we're being told we can only have 50 people in a room. So obviously, I know districts out there are really thinking creatively about virtual graduations, drive-by graduations, trying to create some semblance of these rites of passage. And that may be all that we can do. Just be careful in terms of planning things now so you have those protections in place. Jennifer, I don't know if you had any other thoughts on that.
No, I would just add that this has been a shock to the system as far as overseas trips. We're getting a lot of questions about canceled trips with vendor agreements being between parents, and the complication of what's the school's role in all of that, which is really individual to each trip and situation and how the district involved itself. But we are seeing just a lot of that. And as more and more things get canceled, looking back on those contracts, I'm certainly in some, I know some clients wish they had probably looked at those agreements. No one predicted the pandemic, but going forward, we know that this could reoccur. So if you're entering into new contracts, like Nicki said, this is absolutely the time to scrutinize what does happen if there's a new stay-at-home order, or if that country closes, or if that venue closes.
Yeah, I've negotiated a lot of contracts recently with adding in that pandemic to the force majeure section. So we definitely have to think about things differently. We received a question about the mandate from the joint statement about paying school district employees through the balance of the school year. Shelli, do you think this language applies in summer school?
Well, we have gotten this question, I think, from a handful of clients over the last few weeks, really starting to think forward about, are they going to be able to take this opportunity to perhaps get more kids in summer school for any learning loss that occurred over the last few months? And what happens if that has to be done remotely versus if it's possible that they can come back to school and have instruction in person? And the question really is what if we can't do it? What are our obligations to our staff? And I think that we really have to look at the joint statement, at least as it exists right now, as ending with the end of this school year. I don't see any, authority in the statement the way it exists right now to extend into summer school or perhaps even into next year. We have not seen any districts that I'm aware of push back on the authority to mandate this pay to all staff. I think if there's anything that occurs that moves it into the summer realm or even into next year, we are likely then going to see school districts saying we simply can't do this. And I think the difference with summer school also is that if it is done virtually, you are likely to have parents who are going to pay for summer school classes that help to fund that staffing no longer being interested in that. And that I think will be a different argument to make as to why we don't need to continue doing that. Nicki, I don't know if you've heard the same question, or Dana, but I think that right now I'm looking at it to the end of this natural school year.
I would agree. I think we don't have any guidance for summer. And there was another question about what about non-ESY required summer school? I think that is, again, optional. But if we can't have it, I think you have to keep your options open. I know a lot of districts really depend on summer school, especially high school districts, to have students that failed a class make it up. But also remember, not all kids, we can't fail kids right now. So if you had people taking classes because they failed, you're not going to have summer school for those reasons anymore. You want to sort of revision it to fit the situation that we're in presently. And it's kind of too soon to tell.
I think that's exactly right. I think I think school districts need to keep as much flexibility as possible about summer school at this point. I think it makes sense that ISB and the governor are rolling things out slowly because we just don't know the reality. So we then have to maintain on our school district side enough flexibility. So if we have to cancel summer school or it looks different, we don't have all sorts of staff lined up for that we can't then pay for. So I do think it's somewhat of a wait and see, but keeping that flexibility.
Jennifer, our next question was any changes to timely, meaningful consultation requirements or deadlines? Can you field that one for us?
No changes. So I assume those will be happening remotely.
And then Shelli, we had a question of looking for guidance on employee practices of wearing masks, requirements, consequences. Does the district have to purchase them? What do we think about masks?
Well, I think it's an interesting question that we address now because the different municipalities are making there's different dates as to where you have to be wearing a mask if you're going into an essential business, for instance. So in Evanston, where I live, I think it's actually tomorrow, the 24th, that we have to start wearing masks. I think Oak Park was before that. I think with respect to our, our districts that have essential employees coming in, there's no requirement right now that they are the ones who are, purchasing the masks. That being said, I think if you are having employees come in, and I'm not talking about the N95 mask that kind of hover over your face like the doctors wear, but just some sort of covering, I think is the word that everyone's using as opposed to masks. Making sure that you're being able to provide that. They're being made everywhere. Our local dry cleaners making them. People are really getting resourceful here. They're all over the internet. So I would definitely recommend that all of our school districts who have employees coming in, not only are you maintaining the 6 feet of social distancing, but that you are also being able to provide those to people just to give them an extra level of comfort and safety.
We had a question about sessions where teachers are working with students in the virtual realm. So the question was, can schools record those sessions and replay them? And I guess also, should they? Nicki, you have thoughts on that?
Sure. I mean, there's nothing wrong or unlawful about recording sessions with students. We get a lot of questions, both, one-to-one as well as group, classroom virtual sessions. Certainly you can record them. The sort of murky area, and I, love to get Dana's thoughts on this as well, but the murky area comes in is that a student record? Who gets to see it? Who gets to look at it? I do think that if a teacher, what the U.S. Department of Education has said, at least preliminarily, is if you're recording a Zoom classroom session and you're using it to share with a student who's absent, that doesn't become a student record. You can then destroy the video and move on. The one-to-one sessions, I think, are a little bit of a closer question, because clearly that is a record of the student. And so I think it's an interesting legal argument you could make that if the clinician is simply using it as sort of notes, as their own internal notes, and they're not sharing it with anyone else, that it doesn't become a student record and therefore can be destroyed by the teacher after they utilize it. But I do think that if you do record one-to-one sessions, you need to think through with your attorneys and also with your administrators what you're going to do, how you're going to keep those videos, and whether you're intending to share those with parents before you start engaging in that kind of recording. Dana, I don't know if you had any thoughts.
Yeah, like a very important thing. I mean, I am not a huge fan of recording. That's just me personally, and I'll get into that in a minute. But if you are going to record, it cannot be surreptitiously. No sneaky recording. You've got to provide a really clear notice to everybody that's participating in that session, whether it be one-to-one or whether it be a whole class of 20, that you are going to be recording the session. And that's got to be front and center to everybody, and in a way that parents know too. So I don't think a teacher could just spontaneously decide, one of my kids just had biology, I think at 9:50. The teacher would have had to provide notice that the class was going to be recorded in advance, in a general notice. I'm not saying it has to be every single time you record, but there had to be a general notice before you would record that class. The reason I don't like recording is somewhat because of all those complex record issues that you discussed, but even further, like with the one-on-one session, and you have an older student, who owns the record then if you do get a record request? If it's a social work session, is it the social worker and the student, or is it the social worker, the student, and the parent? And how is the student going to feel about that? And do we want to get into a big argument about that when we wouldn't get into any argument at all if the social worker just checked in with the student for 10 minutes, took notes of what was discussed, and moved on? And that's what you generally do when you're in the building. I think people are skittish, and I get it, but I also know, and I know Shelli and everybody, that we've been doing this for a long time. We have the horror stories of people making up false claims and suing people, but those are so enormously outnumbered by the people that are grateful and positive and participate in a way that, you don't just get sued at every turn. That's not the way it works. So, and thankfully.
So Dane, I mean, I'm just thinking back to the school year. I was noticing a trend even before we went remote of teachers videoing recording students, and for example, recording a student who is misbehaving surreptitiously and then showing the student and say, see what you're doing in my class. Mm-hmm. Regardless of, so I had 3 cases where parents got lawyers basically with that fact pattern. And even aside, so there was sort of the records issues, but there was just the, we are not at a place where parents think that's an appropriate teaching tool. If you're going to do that and show the student, see, here's what your behavior looks like, you have got to tell parents, because that feels to parents very aggressive and assaultive. And even if they can't say what the legal right is, and maybe there isn't technically one, they feel like you violated the law by doing that.
Absolutely. I think right now, during all of this unknown, and this is not a legal term, this is more of a medical term, but bedside manner is the most important thing. If you treat people and with respect and with care and take time, you're going to have less problems later, without question.
Absolutely.
I think the other thing to keep in mind is that to the extent a teacher is trying to, record a lesson, especially to play to a student at a later time, if you have the capability of just recording the teacher, then you avoid some of these student records issues and you still maintain, the ability to share that with somebody who may have missed that lesson for whatever reason.
Yeah, and you can always just have a teacher, record a lesson. So just, put their iPhone up and record a lesson in the house and then broadcast it out to students. And obviously you've got no student record issues whatsoever. So absolutely. Lots of different creative ideas. The big takeaway, do not record surreptitiously. You take nothing else away.
Yes, absolutely. And although it's not as big of an issue with this question, always keep in mind copyright. We're actually going to have an alert coming out in a few days on that. So keep in mind that there's a lot of sticky issues you can get into with recording. So let's switch gears and talk about our questions that we've received during the webinar. So the first question I have on my list here is, for teachers who run extracurricular activities like clubs and intramurals, do they still get paid for these activities? Can districts tell them they have to create lesson plans for those extracurriculars in order to get paid? And I see that Shelli has her hand up for this one.
Well, I think it's a two-part question. I think the first part of it is that yes, they are still getting paid for that work through the school year. The second part of the question, as it's posed, is can we require them to create lesson plans? I think that gets a little trickier. We can require them to do some work related to that extracurricular activity or club, but you want to make sure that to the extent that it's something different that they would otherwise be doing, which obviously it's virtual, but if they don't typically make lesson plans, for instance, that might be not something we don't do for an extracurricular activity, that it's tied enough to the activity and that you're not getting any strong pushback from either the teacher or the union saying it's a lot more work than they would typically have to do. We know out of the joint statement that on the one hand, we have to pay, on the other hand, we can expect some type of work. And when it gets to issues about conflict over the type of work, that's where the unions really need to be involved in helping us figure that out.
We have another question, and I know, Dana, that you touched on this a little bit before, but could you make a distinction between ESY and summer school? What's required, what's not, just as quick and dirty on that?
So I think that's ESY is required for special ed students to prevent regression and help them recoup skills that might be lost for that long period, which we have some guidance on that. You can read it, and that's a distinct thing from summer school, which might be enrichment classes. It might be classes for kids who have failed a class during the regular academic year. It might be elective classes for kids that want to, move ahead in their high school requirements and have an easier schedule during the school year. So those that sort of more optional summer school that districts run, teachers get paid extra for that. You need to look at the contract to see how the contract, what it speaks to about summer school and how people are staffed and all of that. But I think we need to be cautious about planning those summer schools. It may just not happen. And I would really be wary of a student being placed in a required summer program because they failed a class right now, because that would fly right in the face of the guidance on grading and how we're supposed to be, crediting kids for their work during this period. Anything else, Shelli, you can think of as far as the labor implications?
No, I don't think so. I think that gets at it.
Great. And the next question is for Jennifer. Will parents be able to ask for compensatory services once this is over?
We don't know. So yeah, in the broadly speaking, if you deny FAPE, one of the remedies for that is comp ed. So we know that so far parents have not lost any of their rights under IDEA, and certainly they can make a comp ed That could be a claim that they had as far as what the requested relief in a due process. Now, will there be a broader, more systemic comp ed as some sort of, as a condition of federal funding, for example, if there's some federal, what's being talked about is if there's some federal flexibility on timelines and idea requirements, and then some kind of a set amount of comp ed that would go along with accepting that flexibility, or maybe forced on you. Maybe everyone gets the flexibility and has to do the comp ed. We don't know. That is all being negotiated. Betsy DeVos, the Secretary of Education, has to submit a report to and a recommendation to Congress, but then Congress it's a law change. So you're definitely in the making sausage stage of that, and we don't know. But yeah, barring a change in the law, parents maintain their regular remedies right now, which includes comp ed. The calls that I've had recently to brainstorm how we're going to handle this as attorneys quickly devolve into labor discussions, because if you en masse have many, many students that you need to provide extended day or extended portions of the school year, weekend, I don't know, when are you going to do this extra education? Well, who's going to do it? How are you going to pay them? You know, and so it becomes very, very complicated when you think of large scale comp ed.
A lot of open questions on that. All right, next question for Nicki. Due to changes in spending patterns these last few months of the school year, it is very likely that most of us will not meet MOE requirements, maintenance of effort requirements. We will spend less this year per student than last year on special education services. Has there been any discussion about a waiver from the requirements or a modification of the reporting for this year?
Yeah, I know that's got to be on a lot of people's minds. I know that came in from a CSBO, but I know our special ed directors are also looking at that. Unfortunately, I haven't seen anything yet on maintenance of effort, whether there will be some sort of waiver process, whether, you know, the feds and the state will hold districts harmless for this year. I think it's a great question, and I think it's something to, you know, to bring to the attention. I know IESA has their task force. I know other folks are talking with state leaders, and I think it's one that we'll put on our list so that we can get some feedback from the state on how they're thinking about that and what they're hearing from the federal government. It's a great question. Unfortunately, no answers at this point.
Kendra, we got another special ed question. Recently, ISB stressed that students are still required to make measurable progress on their IEP goals during remote learning. This seems to be in conflict with guidance for general education, where we are recommending pass or incomplete for grades. Are districts okay to indicate participated for progress reports versus percentage accuracy?
Yeah, that's a really good question. And I think there are a lot of considerations that go into this. So we still have the requirement to provide FAPE. How much progress is appropriate and reasonable to expect when we're doing remote learning might be different than the amount of progress a student would make, in the school building with, directly with the teacher and with peers. So I don't think that, at least the argument that, we as school attorneys would make is that the FAPE requirement, it's not going to be necessarily, you're going to make exactly the same progress that you would have. That said, I think districts are going to be in a better position to defend against potential requests for compensatory education if you can collect additional progress monitoring data and show that you're offering these services and that kids are hopefully maintaining and even gaining some skills. And so definitely you want to be documenting whether a student is participating or not. That's sort of baseline, we're offering these services, whether or not the student is availing themselves. But then beyond that, if you are able to think of creative ways to gather some data about the student's performance, their growth, areas where they're still having additional needs, that additional information will better position the school if there is a dispute later.
And I want to add to that too. What I have a concern about, or what I've seen play out in some IEP meetings and parent complaints that we're seeing, is that students, when they come home, they're not able to do at home what you told the parents they were doing at school. And maybe that's because, you, let's say a pretty significantly disabled student, you were doing a lot of support. You were they could write a sentence with a one-to-one support and a visual model and this and that, you know, all of these things. And then you told the parent, all the parent heard was they can write a sentence. And then now they're home and you're sending home these worksheets and the parents like, yeah, they can't do any of this. What were you talking about? In my perfect world, I would get some sort of benchmark. We know that student performance is different in different settings. In my absolute perfect world, I would have some new benchmarking going on right now so that we're not saying the regression is all because of our services, but maybe because of the setting, maybe because the scaffolding's not there. And we start to work off of where they are given the setting, and we can show some progress from the remote services, because it's very unlikely that you can show progress the way some of these goals were drafted for all the in-school support.
Great. Dana, we had another special ed question. If we previously listed IEP minutes for ESY services that were written into the document to parallel our traditionally designed in-person learning, but now we want to adjust those minutes as we create remote ESY opportunities, do we need to amend the IEP documents?
Well, I think it sounds like you made the person asking the question made their IEP documents pretty specific in regard to ESY. And if that's the case and you're not going to be able to meet the minutes that you've promised, you likely should reach out to that parent and make a proposal. And if just in the same way we did remote learning plans, if they agree, if they look at your proposal and say, this is fine, I agree with this, that you would just do an amendment. And if they don't agree, then you would have to, you know, convene some sort of a meeting to discuss what the ESY program is going to be. So, I mean, I think to the extent that you haven't, you know, if you're still having annual reviews and you're still looking at the ESY question, you do want to give yourself flexibility in the IEPs that you haven't finished yet. And that will make for a little bit of less going back and forth later down in the road.
Okay, we had a question that Nicki was going to answer. Do you recommend districts send community communication if a staff member or student receives a diagnosis of COVID-19?
Sure, and I'd love others to weigh in on this. I certainly think that if you have an employee who's been working in one of your buildings who notifies you that they've contracted COVID, you should send out a communication to the staff that are working with that person in the building that could have become exposed. Obviously, you should not use the employee's name, and to the extent possible, you should obscure any specific information about them. But you do want to alert at least the fellow employees who are working with them that there has been someone who's been diagnosed. In terms of students, again, if students are at home, obviously there's no need to alert anybody, in order to make sure that folks are safe and aware that someone has contracted COVID. Shelli, I don't know if you had any thoughts on that as well.
I think that, I think contacting the public health department and making sure that the employee or you, the employer, are contacting them and then following their guidelines around that. I mean, I think that they've been giving I think some employers are having a tough time getting a hold of them because there's, a lot of people reaching out, but making sure that you're kind of following that guidance as to, what specific information needs to be provided. If the person's actually just been exposed to or is actually tested positive, I think changes the information you give out. Most importantly, I think just what Nicki said about making sure that you are not disclosing the identity of the person, or that anything that you're saying could inadvertently be disclosing the identity of the person who you're speaking about. But, the idea here is just about keeping everybody as safe as possible, making sure that to the extent that we have employees who need to come in, that we are not exposing them in a way that they don't otherwise need to be exposed, because we've given them some other, information or some protective gear.
Great. Okay, so another special education one for Dana.
There was one about, kids, sort of following up on what Jennifer talked about earlier with the school avoidant kids. And, a parent claiming, you know, my child has respiratory issues, no way, no how are they coming back to school until we have a vaccine? And, you know, Jen, what do you think the answer to that one is?
I think we require, at this point, we still require the medical certification. So I'm thinking about some of the waivers on the COVID, you know, on the employee side. We don't have where you don't have to get a doctor's certification because in theory, it's not safe to go to the doctor. We don't have anything similar to that on the student side. So as of now, I would require a doctor's certification, and that is so someone is monitoring this and someone's talking to the parent besides you. The medical professional is talking to them. And once you get that medical certification under Illinois law, it's kind of out of your hands. At that point, you have to do homebound, but at least force the parent to have that discussion with the medical provider.
And I think, you know, some districts do this differently, but having the homebound certification last for a given amount of time. So it's not just an indefinite, you know, until the student, you know, until there's a vaccine or until let's reassess the situation every quarter or every, you know, trimester, whenever the school breaks up the time to make sure that this is still a necessity. And if the student can come back, we're able to transition so the student is in school.
Right. Right. Every 30 days, every 60 days, not until there's a vaccine. That not to be a downer, but that's way too open-ended. You're going to lose track of that kid.
Nicki, are there any recommendations for one-to-one meetings between a teacher and a student? For example, a music teacher who wants to do individual lessons with students.
Yeah, absolutely. And we're seeing a lot of this, you know, both in the special ed and in general ed, and the music teacher is a great example of that. So I think with one-to-one, you can absolutely do it. We talked about this before. I think notification to parents. And I think, you know, for one-to-one, you could either do a written consent form that would be sort of belts and suspenders. So having a parent consent to the one-on-one sessions. You could also do what we sort of refer to as passive consent. You know, we're going to do one-to-one music lessons with your child. If you don't want that to happen, you know, let us know, and we will not conduct those. So I think notifying parents and giving them either a written or passive consent, I think is important for one-to-one. Some other, you know, sort of tips, I think, consistent, you know, likely with what we're telling you in terms of group sessions as well, which is, you know, particularly with one-to-one, it'd be great if, especially for the younger kiddos, to have a parent check in with the teacher, you know, at the beginning of the Zoom call or the whatever video conferencing you're using, just to let them know, hey, we're here, thanks for getting the kid on, and then have the kiddo do that. Ask them that they hold the lessons in a public part of the house so that they're in the living room, they're in the dining room, not in a bedroom. Having them done during school hours to the extent that that's possible. So not holding these kinds of video conferencing at 7 o'clock at night. So I think those, you know, would be great tips to make the one-to-one a little bit more comfortable for everybody. You can certainly have the parent in the room, especially with those younger kiddos. There's no reason not to have the parent present if they're able, or just in the background so that you know that they're there and listening in. And obviously using all of the video conferencing privacy tools that we've talked about in our alerts and in other sessions. So, you know, the teacher is the one that initiates. They only send the link for the call or the video conference to the parent or the student, if it's a high school student or maybe a middle school student. They use the waiting room features. They use all of the privacy controls that they have at their disposal as well.
The other thing I think is important, and along with all of what Nicki just said, is that for the protection of our teachers and our school districts generally, is for those teachers to keep a log of some sort about the communications that they're having, especially if they're one-on-one with kids, so that there's no question that if an allegation comes up months from now, that you can say, on this day, I had a one-on-one session with Nicki from this time to this time. You either did or did not have consent of parent, mom. I mean, just notes to yourself so that the teachers can go back and be able to, I mean, this is all happening in real time for everyone. And you have your own kids, your teachers, you have your own kids running around trying to do their own virtual learning. You're going to forget things that could be important to protect you in the districts one day. So I think as much information as you can record for yourself, or administrators who are listening can let their teachers know to keep a log of some sort for themselves, just so we're all kind of protected with the same information moving forward.
Yeah, and of course, tell your teachers, administrators that if something occurs during one of these sessions that they're uncomfortable with, that they notify you immediately. Obviously, as we've talked about before, DCFS reporting, mandated reporter requirements are still in effect. But even if it's nothing that rises to that level, but they're just concerned about something, that they have open lines of communication with you and that you are also taking note of anything that occurred and maybe following up with the parents as necessary.
That's great advice. So we have one more special education question, which Jennifer raised her hand on. So this says, I think we're going to have a huge increase in attendance refusal, particularly since work refusal was so prevalent pre-COVID. How can I guide my districts on when to touch base with attorneys prior to using behavior strategies to help with school attendance?
So definitely this is not something that should go straight to attorneys. You should use all your interventions, exhaust your interventions that you have. And what if it gets to the point where you're bringing truancy charges against the parent or referring to the state's attorney, depending on how the county you're in handles it, those are, I've seen those seldom be effective and almost always result in terrible relationships with parents that do not go well from that point forward. So your teacher interventions, your BC, all the softer touches, the restorative ways that you can communicate about attendance are going, you want to absolutely exhaust those before you think about threatening the legal action or referral to a state's attorney.
Okay, Shelli, we have one additional labor and employment question. As a follow-up to the COVID diagnosis and informing employees who work with the employee diagnosed with COVID, if the employee has not been working in the buildings, but rather at home for quite some time, do we still have the requirement to share this information with the coworkers?
I would say that's, really specific as to how long the employee's been working at home, when they last were around their coworkers, and when you expect them to be back with their coworkers. I think so. We have to look at all of that, and the real crux of this should be, what is the likelihood that any of those other people who were around that person could have been exposed and should therefore be tested? Or alternatively, is there a likelihood that that person could be coming back into the school community and then exposing people? So I think we really have to look at the specifics of that employee's job and when they last worked for us and when they'll be coming back into the school environment to determine that.
All right, I think we have time for one more question. Before I get to it, though, I do want to let everyone know that next week we are again going to have a special guest, and we are excited to have a very special guest, our own Jim Franczek, the founder of our firm, who has been working hand in hand with lawmakers and folks who are thinking through some of the biggest questions during this crisis. So please make sure to join us next week for this webinar at the same time. And we'll obviously send out notices about that by email as well as on Twitter. So let's get to this final question. And Shelli, you had your hand up for this one. So our support staff evaluations are due toward the end of May. Given that we are currently out for the rest of the year and will have been out for the entire fourth quarter, are we still required to write the evaluations and hold evaluation meetings remotely with these staff members?
It's a great question. And it's a little bit different than we have for teachers, because our teaching staff, their evaluation is really dictated by the school code, whereas in the realm of support staff, that's typically dictated by your collective bargaining agreement. So making sure that you are looking at what your agreement requires. So the question of, are we required to do it? It really depends on what happens if you don't. And if your collective bargaining agreement is silent, what I've been advising clients is to talk to their union presidents and talk about, are there specific individuals that need to be evaluated? So for instance, I did have a client ask a question about some support staff that they were having some issues with. And if they, per their agreement, if they don't finish the evaluation, then that person can't be let go for a certain amount of time. And really working with the union and saying, look, we identified these problems before. The only piece we have to do now is to actually meet with the person, and making sure that you do that virtually and give that person the evaluation so that you can take advantage of what other benefits you have in terms of their employment situation moving forward, and are not restricted by doing that just because we happen to be out of school right now.
All right. Thank you so much, everyone. Thank you, Kendra, for joining us today. And to the rest of our panel, and to all of you for joining us. We have been overwhelmed with the support that you guys have shown us by joining us for these webinars. We hope that you'll continue to do so. If you have any questions that we didn't get to today, please feel free to reach out to one of us. And otherwise, we will see you next week. Take care, everyone.
Bye, everyone.
Bye, everybody.
Bye, thanks.